Hello.
Good afternoon. I am live. I'll turn the recorder on. Got several people in the waiting room. I've got Devon Berger in here, who I believe waived prelim last week, and he had a notice. I've had several people that showed up either on the wrong date or the wrong place. I'm going to bring him in. Who was his lawyer? 6. Christine. First it was Luke, and then it was Christine. Mr. Berger, can you hear me?
Yes, sir.
Your matter was set for a pre-exam conference on June 15th and a prelim on June 22nd. You waived the matter and allowed it to be bound over to the circuit court on June 15th, which means we didn't need a preliminary examination for today. So there will be no hearing today. Your original lawyer was Mr. Knopfinger. He is here. Your current lawyer is Christine Yancey. I suggest you simply stay in contact with her. But you don't have a hearing today because you waived preliminary examination last week. So I'm going to release you and you're free to go about your business. As I said, you've been very conscientious about appearing once on the wrong day, and now you didn't need to come either, but you wanted to make sure you didn't miss a court date, and I appreciate that.
Yeah.
So you haven't missed anything. Your matter's bound over to circuit court, and there'll be no hearing here today. All right, thank you. Now I have John Bush. I haven't seen anyone from the jail yet. And I have Galaxy A12. Let's see who this is. This is Mr. Higgins, I think.
He's in custody.
Oh, yeah. Well, this isn't Sean. Is that you, Sean? Yes, it is.
Yeah.
All right, Sean, can you hear me? Always takes a few minutes to just get all our waterfowl aligned. Does the jail know we need those people? We need Summy and we need Higgins. Sean, can you hear me yet?
Booking office.
Hi, booking office, Judge Middleton. We got prelims this afternoon. We need to see Dwight Summy and Charles Higgins.
Your Honor, Dwight Summey's on bond.
Oh, just Higgins then, I guess. That's it.
Charles Summy, right?
We don't need to see any Summy.
Oh, I don't need to see Summy.
No, just Mr. Higgins.
Okay, I'll get him up there.
All right, thank you.
Yeah.
Bye. All right, I've got Officer Hewitt and Officer Greenhalgh in the waiting room. I'll bring them in, turn off their screen so they can see what's going on. Sean, can you hear me? I'm gonna turn off your screen, Officer Hewitt. You can watch us here. Sean, can you hear me? You need to take off your hat. And you need to turn your audio on. Mr. Moore, can you hear me? May I get 2 tin cans and a piece of string? All right, Sean, you need to turn your sound on. You got your hand up. You've done this before. You need to hit the little sound thing down in the lower corner. I'm not sure what you're in here on, a laptop or a phone. Now, I don't have Mr. Pebler again.
He's on bond. He should be hooked up remotely, hopefully, Your Honor.
Well, he's kind of in the wind a little bit. We can't do anything. We can't hear Mr. Moore, and no one else is here. Deborah, I will indicate that you have filed an order of dismissal in the file 211155, People versus William Randall Elkins. You stated the reasons for the dismissal, and I will sign it and order that the bond be canceled and returned if necessary.
Thank you, Your Honor.
Now we have Charles Higgins, who we're waiting for, Ken Pebler, who we are waiting for, Dwight Summey, who we are waiting for, Sean Moore, who's here, but we can't hear him. So we're batting about 0. Sean, if you can hear me, raise your hand.
I mean, he pushed the raise hand icon, but
Yes.
I don't
Yes,
think
'cause
he can hear us at all. Does somebody have his phone number? It's John Bush's
I
case, right?
have a phone number. I'm not sure it's accurate.
I think he just didn't push the join using computer audio.
Yes.
So he's not gonna be able to hear us.
I'm going to kick him out and have him start over again. Well, hello, everyone. Here we are. Can't do anything. As you know, we got the memorandum from the Michigan Supreme Court yesterday saying that all the courts are to advance to phase 4 and reopen for more complete and full service. We're waiting for further instruction regarding that, but we are going to be returning to more of an in-person court. I also encourage us to do as many things as we can virtually.
Can you turn it down a little bit?
All right, I got the jail, but I got no audio. That's a new one. I got audio, but no video, excuse me. Luke, were you messing with the controls again?
I was, yeah. That's
Not
prank.
you, Luke at the jail.
Oh, we have a, yeah.
You must have a guilty conscience as you were.
I do have a,
Here's
Yep.
Sean. All right, we're getting closer. Sean, could you unmute your mic Unmute your microphone. You should be able to hear me now.
Can you hear me?
Yes, very good. Good afternoon. First thing, you need to take your hat off, Sean. Pretend like we're at a court proceeding. Good afternoon.
Good afternoon.
We've been waiting to get started on several things, and we might as well start with you now that we've got sound and video. This is file 21981FY, People versus Sean Carson Moore. Mr. Moore is represented by attorney John Bush. He was originally charged in this matter with possession of methamphetamine, use of a controlled substance, and possession of ammunition by a felon. He pled guilty to use of methamphetamine on May 25th, and I left the matter scheduled for sentencing. I believe it was scheduled for sentencing for June 14th. And you and I had talked, I believe, on Thursday. You were still in custody. You wanted to get out of custody. And I said, we will deal with this on Monday. Somehow, over the weekend, between June 12th and the 5th, no, June 11th and the 14th, the jail mistakenly released you from custody. And you didn't show up for your hearing on Monday. Mr. Bush and I were there. Miss Davis was there. You didn't show up. I tried calling you a couple of times. I waited 48 hours and then I issued a warrant. Then you called the court and said, what's going on? So we directed court staff to set this for hearing today at 1 o'clock because your lawyer would be scheduled to be here. I understand why you're confused because I told you I would see you Monday and someone at the jail mistakenly released you. It's a good thing it wasn't something more serious than this. You were in custody from May 10th to, I believe, midnight on Saturday night, June 12th. So you did 32 days in jail. What you failed to appear for was the sentence. My intention at that point, Sean, was to just give you time served. You were in a big yank to get back to work. Have you gotten back to work?
No, actually, this warrant kind of stopped me.
Well, you didn't. I was dissatisfied because I had talked to you about it and said, we'll deal with it on Monday. Then you didn't show up. Then I tried to call you. I couldn't get through to you. But in your defense, maybe you thought it got dismissed.
Yes, that's exactly what happened.
All right. Where are you staying?
Actually, I'm homeless right now. The Keystone was supposed to be the next best thing, but they told me at the county jail, just you're leaving on the 11th. And when the 11th came, they said I had to do a pay or stay, and I did a pay or stay. I don't know how
they screwed it up. So someone, we won't go into any more detail, but it was a mistake. Deborah and John, after everything that Judge Pattison just went through with Mr. Moore, the fact that he did this jail time, he's homeless. My intention on that day was to give him time served. He actually got out, I guess, about 2 days early.
I thought that was the agreement. Actually, oh my God.
All right. Does anybody have any further input? Deborah, anything you wish to say?
No, I don't fault him. I mean, I guess if I was in jail and somebody said you're getting out, I would take that opportunity. And I'm sad that he didn't show up on Monday, but the confusion seems to be legitimate. So I have no issue with the court going forward with what the plan was originally and simply giving him time served. Thank you.
John, anything further?
I'd ask the court to implement that, Your Honor.
Sean, can you hear me? No struggle. We lost him. Luke or somebody at the jail, could you turn the video on? These are the things that Judge.
Video.
All right, Sean, are you back with us? All right. We need to turn the video on at the jail. We lost Sean Moore. These are the things that drive Judge Pattison crazy and why he is absolutely over Zoom and would like to return to in-person proceedings for everything. I've got more mixed feelings about it, but these things are certainly vexatious to the spirit. Well, we've got dead air at the jail. Debbie, are you texting them?
I was texting my officers for the prelim
Oh,
to let them know what's going on, but I don't have Luke's number.
They were saying the video or something.
Sheriff's Office booking.
hey, booking. The video's turned off at the jail. All we got is audio.
I have her.
Now we lost them all together.
She's gonna dial back.
All right. All right. Thanks. All right. There's just the normal noises in here. Nobody knows what that means, but all right, here's the jail again. There we go. Mr. Higgins, can you hear me and see me?
Yeah, a little bit. I can see a little bit.
All right.
All right,
How do I look?
You look handsome.
You didn't have to go that far. All right.
I was always telling my dad, man, look handsome, you know, so.
All right, just a minute. We were dealing with another client and we lost him. And
Yeah.
so, all right, let's deal with this one. All right. This is file 211109. It's entitled People versus Charles Maurice Higgins. Mr. Higgins is represented by attorney Luke Knopfinger, who is present. Mr. Higgins is in custody at the jail where he's been for 21 days. He is charged on a complaint that alleges on or about June 1st that he assaulted Cinquez Furlow with an intent to do great bodily harm by strangulation. Count 1, that's a felony punishable by up to 10 years imprisonment. Count 2, that he possessed the controlled substance cocaine, which is a 4-year felony as a second subsequent offender, which makes it an 8-year maximum. It's also alleged that he pled guilty to that he was also charged with possession of heroin, a 4-year felony as a second offense. He's also charged with assault with a dangerous weapon upon Cinquez Furlow using a gun. He's also charged as being a felon in possession of a firearm as a 4th habitual offender. This matter is set for a preliminary examination today. Officers Hewitt and Greenhalgh are here. Not sure who else is here. Deborah Davis is here, and Luke Nossinger is here. It's my understanding that Mr. Higgins is going to waive his right to a preliminary examination on this matter. And then before I sign the bind over, the parties wish to be heard regarding bond. Is that correct, Mr. Nossinger?
Yeah, could I argue bond first, and then I don't have a signed waiver, and then what we could do is have an oral waiver on the record.
That's what I thought we would do. Let's go through that. I won't sign it, and then we'll take up bond. All right, Mr. Higgins, I told you what the charges were. You have a right to have a preliminary examination in this matter where it must be shown in a standard of probable cause that a crime was committed and that you did it. That is not proof beyond a reasonable doubt. It's simply probable cause. The language regarding the waiver says, I, Charles Maurice Higgins, understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one. I have a right to a preliminary examination where it must be shown that a crime was committed and probable cause exists to charge me with the crime. I voluntarily waive my right to a preliminary examination and understand that I will be bound over to the circuit court in the charges in the complaint and warrant or as amended. That means the matter would be bound over to circuit court for further discussions up to and including a trial. Do you understand?
Yeah.
Is that what you wish to do here?
Yeah, from my understanding, it was, that my
Just a
bond would
minute.
be lowered.
Well, that was discussed, but I want to make sure we get the waiver down. All right, now you agree to the waiver, Deborah?
Yes, we would accept the waiver.
All right, Luke, what would you like me to know about the bond?
Yeah, and as Mr. Higgins has indicated, well, a couple things. I understand that they can be considered pretty serious charges. Mr. Higgins has he has ties to the community. He has appeared at court hearings in the past. He has waived his preliminary exam. He does have children that he has to support, and he wants to do that. He is fortunate enough to have a job that would take him upon release. And this is an argument I've made in the past too, that given his financial resources, his current bond at this point might as well be no bond. So what we would be asking for, I think, is a bond in the range of $15,000. I think that weighs both the interest protection of society, and then also some assurance that Mr. Higgins will appear and cooperate in future hearings. Thank you.
All right, I had an opportunity to meet with counsel before lunch, discuss this afternoon's case flow, and there was an indication there would be a motion regarding bond in this case. Ms. Davis, anything further to add here?
Your Honor, these charges are very serious. We do have some reservations about whether or not our complaining witness is going to cooperate. They were not able to get her served with a subpoena for today. So, but for the waiver, we would have been asking to adjourn to give us another week or two to find her. The officers, the lead officer is out on a leave right now. And so there was other officers attempting to serve her, but with the tornadic weather that we had, they were not able to get her served. So under those circumstances, I would leave it to the court's discretion of what to do with the bond. If the court is to lower the bond, we would request that there still be a no contact order between the complaining witness and Mr. Higgins. I understand they do have a child that is, I don't think it's a child in common, but a child that he may be the father figure toward. Wouldn't have any objection to him having contact with that child, but it would have to be done through a third party. Again, we have concern about her cooperation, so the no contact would be important to have in place at this time. Thank you.
And I'm sorry,
All
Mr.
right.
Higgins is agreeable to any bond conditions the court would further impose.
All right.
I'll have a time on the way with her too.
Yeah, somebody mentioned that. All right, you can't have contact with her or you'll end up back in jail under the order of the circuit court. I'm going to reduce the bond to $15,000 cash or surety. All conditions remain the same. My suggestion is if you do make the bond, you contact your lawyer, Mr. Knopfinger, with your address, because I had a Kalamazoo address of your dad's and an Erie Street address and Three Rivers. I'm not sure which was which. So you're also to advise your attorney of your address and phone number.
All right.
Don't-
There was huh?
Don't do it here on the record. I'll accept your waiver. Bond is reduced to $15,000 cash or surety. The matter will be bound over to the circuit court, and I request that you contact your attorney if you do post the bond. Thank you, Mr. Higgins. The next proceeding will be circuit court. All right. Oops, I must remove the wrong party.
Call me Charles.
Yeah.
Okay.
All right.
All right. Thank you.
We'll see you.
All right, we'll remove the jail. Someone else may need it. All right, Luke, does that finish your obligations?
It does for this afternoon. Thank you. See you guys.
All right, thank you. Your witnesses, Mr. Hewitt and Mr. Greenhog, may also be excused. Are
Yes.
they both here on that case?
Yes, they're both here for that one.
All right, I'll remove Officer Greenhog and I'll remove Officer Hewitt. Any
Thank you.
questions, call the prosecutor's office and talk to Ms. Davis. Thank you. All right, now I have Dwight Summey has joined us and a phone number. Let's see who this is. I'm very disappointed we lost Mr. Moore. He does have a probation violation hearing for June 30th. So he may have some other issues, but here he is again. All right, Mr. Moore, unmute your mic.
Yeah. Yes, sir. Sorry about that.
Don't dump.
Okay. I'm going to order on this use of methamphetamine charge, 31 days, credit 31 days.
Thank you.
I'm going to waive the fines. I'm going to waive the attorney fee. I'm going to order the minimum fine of $125. That is due by July 31, 21. Now, I want to remind you, you still have a case pending in front of Judge Pattison. You have a probation violation hearing set for June 30th, which is next Wednesday. Let me see what time that is. And it's in front of Judge Pattison. And that will be set for 10:30 a.m. So no matter what anybody tells you, or the jail lets you go, or the snow falls, you have another court date next Wednesday at 10:30. But that resolves this case, Sean, and I will recall a warrant that's out for your arrest.
All right. I appreciate you.
All right, you had done a bunch of other jail time before this, and we'll call this good, and you still got a PV pending.
Okay.
All right, you seem good today, and I think that's a good thing. Keep your train on the track until you see Judge Pattison next Wednesday.
All right.
All right,
Good
I'll
luck, Mr.
recall
Moore.
the warrant for your arrest. All right, thank you. Okay, recall warrant. John, no luck with Mr. Pebler. Perhaps you could try calling him while we work on Mr. Summey.
I know my secretary has had a couple phone conversations with him today, so.
All right, well, I hope he comes in. He's not here yet.
We will work on that directly. I'm not gonna disconnect, I'm just gonna walk away from the screen.
All right, thank you. I'll mute your mic. Oops. Yeah, there we go. Good morning, sir. Good afternoon, sir. Are you Dwight Allen Summey?
Yes, sir.
Mr. Summey, you have two cases pending here today. You posted a substantial bond, a $20,000 bond in one case and a $15,000 in another case. In file 21887, you're charged with criminal sexual conduct in the third degree, which is a felony punishable by up to 15 years imprisonment. In file 21886, you're charged with criminal sexual conduct first degree, which is punishable by up to life imprisonment. You've posted $45,000 worth of surety bonds. The matter was set for a preliminary examination today, and that examination would entail taking testimony from witnesses. I was speaking with your lawyer and the prosecutor by email late yesterday afternoon. The law says that you have a right to have it, I guess I can say it in this juncture, a polygraph examination when you're charged with this type of offense. And apparently they were unable to schedule that. And it's my understanding you wish to adjourn this preliminary examination so you can avail yourselves of your additional rights in this case. Is that correct, Mr. Summey?
Yes, it is. And I do have witnesses and.
All right, well, don't say more about that. And Tim, you agree?
Yes, Your Honor.
Now, what we had discussed is a 2-week adjournment.
That's correct, Your Honor. And so the court's aware, and I know I'm sure Miss Davis is aware as well. I did receive information this morning that is scheduled for next Tuesday. So I do believe that we should be able to get any information in time if we did set it out for 2 weeks.
All right, defendant agrees with the adjournment. Case is adjourned to my next date, which would be July 6th. That'll be a great thing to do on our first day back from at 1 o'clock for preliminary examination, both cases. Mr. Summey, there are bond conditions in effect. They remain in effect. You're not to have any contact with any of the witnesses in either of these cases. Do you understand?
Yes, I do.
All right, you stay in contact with your lawyer, Mr. George. He'll tell you when and where you need to be for that test. Otherwise, I will see you 2 weeks from today at this same time, 1 o'clock. Do you have any questions?
Yeah, I have another case going on in the background. It's for B&E, and it's on the 6th of next month at 1 o'clock, I think.
What case, what county is that in?
Oh, it's in this county. He's
All
got
right.
a circuit court case that's pending.
All right, well, who's your lawyer in that case? All right. Which B&E is that? Is that,
Glen Oaks,
where is it? Deborah?
at Glen Oaks.
Okay. All right, there have been a rash of B&Es out in the Parkville Road area. I don't know, this apparently wasn't one of those. I mean, a bunch of them. All right, Mr. Summey, you stay in contact with your lawyer, Mr. George. And it's important you be here for these cases at 1 o'clock. And if there's a conflict, these cases are going to take priority because they would involve witness testimony. If the matter is otherwise resolved, we may not need to have a preliminary examination in these matters. All right, you're free to go.
Okay, thank you.
Tim, anything else we need to put on the record?
I believe that's it for me, Your Honor. Thank you.
All right, thank you. Well, Mr. Peddler, any luck with the phone, John? You're on mute.
You hear me now?
Yes.
Is there any way we could check and see if you got confused and checked in with Judge Pattison by any chance? He talked to my office like at 11:30 this morning, and they confirmed he needed to be in court at 1 o'clock to do the waiver.
All right, I'll ask him.
I know that's a long shot, but it's.
Well, he also had that bond violation because I told him that I wanted him to go to the day reporting center and he did not. So I don't know if he's worried about that. No luck there. I thought we called him last week and he said, it slipped my mind. So apparently this wasn't all that important to him. That and his demeanor led me to think maybe we needed a test, and he didn't show up for it. Judge Pattison just indicated he is not logged in on his side.
Thank you for checking, Judge. I was just hoping maybe that was the mistake.
I think maybe he's afraid of what I was going to do about the missed test, but it's a pain in the neck when people don't show up when they're supposed to, because we have to chase our tails around and do a bench warrant and reset everything. That's why I often try to call people on the telephone, because as much of a pain as that is, it's less of a pain than everything that goes with that. So I'm going to issue a bench warrant, bond is $25,000 PR. Now it's $25,000 cash or surety. The law requires I hold it 48 hours. This is the pain in the neck part. I think he's not here on purpose. I think he's struggling and he's afraid of what I'm going to do, which wasn't going to be all that terrible, and he's afraid to come. But we need to get him here and figure out what he wants to do on this charge. And if the matter's bound over, the testing will be circuit court's issue. Anyway, $25,000 cash or surety, hold 48 hours. If you can get a hold of him, John, I'll be here all afternoon.
All right, can I ask a procedural question you may not know the answer to?
Yes?
I'm hoping to be out of town on the morning of July 2nd. That's that Friday. I have no problem doing things remotely. Are we going to be ordered back face to face in the next couple of days, do you think?
No. And there's no consensus on what we're going to do live and what we aren't. We need to meet the 4 judges. Judge Stutzman is in the middle of that assault with intent to murder trial, our first jury trial in a year and a half. And so he's unavailable. So no, we'll still be virtual. All the notices for the defendants are all out virtually. July 2nd's a terrible day. People want to get away for the 4th of July holiday. I think Judge Pattison may be gone that day. I'm stacked morning to afternoon. I thought, well, how did I do that to myself? Anyway, we will still be virtual by July 2nd.
I can handle that from Cincinnati then if I need to. That's fine. So.
All right. How many do you have?
Bench trials off that day. Could have been
Excuse
even
me?
worse.
Well, that Pontius bench trial got stuck. I still haven't figured out how it got put on there.
I think.
Worst.
Are we moving that? Or I mean, I can't stipulate to it, but I told Debbie I don't have a personal problem moving it.
No, we're going to have to move it. It got put on there by mistake. In fact, I saw it was still there. I thought it already was moved.
Did you see we also have a bond violation hearing that morning? Do I need to have call witnesses?
Who's that on?
Brandy Lemmerhart.
Yeah, that was set intentionally because the attorney would be here that day. I don't know. I would talk to the attorney and see what we know. But
Okay.
I need to get that Pontius case off of there. That's like
We'll let
busiest.
Mr. Pontius. I'm a good. I have his pre-trials now, so I can do those from Andrew's office, home office, very easily. So I'm fine.
All right. How's the weather in Cincinnati on July 2nd? About 105?
No, probably about 103.
Yes. Okay. All right.
He's getting old. It'll be his 31st birthday on the 3rd. So.
I've been experiencing that same thing. All right, John, thank you for your help. If Mr. Pebler, you can find him, email us or call. We'll try to deal with it this afternoon.
Thank you, Judge.
All right, Deborah, is there any other business we need to transact?
No, I think that covered everything.
Okay, I'll stop the live feed and stop the recording. I have another busy day tomorrow. We didn't end up taking any tests.